Tired of bail matter, my lord. Tired of bail matter, my lord.
Adjourn bail matter. Lordship, interim bail, threatening the marriage function of its sister. Lordship.
No, appeal bail, my lord. Appeal bail.
So SC appeal not listed, मैंने specific reason.
Please.
Adjourn bail matter मेरा ठीक ना.
Tired of matter. মানে ইন্টারিম বেল মদরে সিরিয়াসলি 26 তারিখ ଥିଲା গতকালি আଜି আস
दे appellant in custody since. Give it.
But the appeal bail matters.
Your Lordship, appellant in custody since more than 5 years out of 10 years.
Bail matter.
Yes, sir.
Please give it.
Give
it. Yes, sir.
My lord, tied up bail matter.
বেল ম্যাটার মেলড অপেলেন্ট ইন কাস্টডি মোর দ্যান 8
Please give it.
My lord, fresh bail in juvenile.
Give it.
my lord fresh bail matter placed my lord 28 item number 28 this leave to continue appeal. So Mrs. Jyotsnarani Tripaঠি's name is there. Her name may be deleted and my name may kindly be reflected. And
Items?
28. So leave to continue. Your Lordship may allow my name may kindly be reflected. I may not be there. I will be in court number 15. So
All right, I'll just record your name. Let the land and council come. You may not remain. I will mention your name.
I'll be in court number another.
It's all right. I will mention your name.
Okay,
I'm just taking note of
Maybe allowed. I have no
Yes.
objection.
Okay.
Leave to continue.
All right.
Supplemental list, item number 1.
May I please, my lord? My lord, the appellant has been convicted under section 376(1)(506) of IPC and sentenced to undergo RI for 10 years.
10 years.
My lord.
All right. Same order, but name is. All right. Admit. Next.
Item 3.
In convict.
Item 5.
May I promise? Appellant convicted under section 13(2) reduced 13(1)(d) and 7 of the PC Act, sentenced to undergo RI for 2 years, pay a fine of rupees often
5,000.
5,000.
7. Then
Operating
again
fine.
2 years and 5,000 under 13 to 13(1)(d). concurrently. So
concurrent.
it's 2 years. You are on bail during that.
Lordship,
Yes?
Lordship.
Yes, Mr. Das.
I will file my appearance by the end of May, my lord. May 2024.
Heard Mr. Sanjay Kumar Das, learned standing counsel for the Vigilance Department, admit he was on bail, bail allowed, stay realization of fine, and henceforth the name of Mr. Das to be reflected. Free copy of the order be handed over to the. Yes, next.
Item 6.
May appeal. Conviction under section 20B 2B of NDPS Act 3 year my lord.
Operative party is at page
Page my lord 25 running page
31.
31.
31.
31.
RI for 3 years, 25,000 in default to undergo so and so. Okay. You were on bail during trial.
Yes, my lord.
All right. Admit he was on bail, bail granted, stay realization of fine. Yes.
Full yes.
Item 7.
You have given the names.
Even the name, it's 7 or 8 notice you.
Acha. But admit lawyers engaged. Notice, notice registry. No, you do it, Mr. The note since one of the offenses concerns notice is to be sent. Land counsel for the state submits that he will
376 3 years.
since one of the offenses under section so on so on, will send the notice to the concerned IAC for its service on the informant in so and so PS case number so on. Okay. So that order is to be passed in 7 and 8. 7 and 8 notice. All right. And admit and lawyers are engaged. And 9 also admit delay condone karibe sabutre delay achi. Hello. And yes, admit delay condone lawyers engaged payments. Yes, next.
Item 11.
Yes, what is this appeal for Mr. Das?
My lord, 376 or 307 8 posts ଅଛି.
Hmm.
ଇଏ ରହିଲେ କାହିଁ ଫାଇଲ କରୁଛନ୍ତି? PSST ତ ନାହିଁ କିଛି ବେଲ ପାଇଁ।
Rejection, এটা কোনটা এটা?
বেল
Bail তো? Rejection order কোন দেখে?
page 16 my lord.
16. Rejection order annex କରିଛନ୍ତି ଦେଖିଲେ ଏଠି
ଆଜ୍ଞା।
କଣ ପ୍ରାୟ?
19/2021 ର 4
ଏଇ rejection order annex ଏଇ
2021 ମସିହା।
କାଇଁ? All right, none appears for the appellant. The learned counsel for the state has pointed out that rejection order is dated
19/4/2021.
19/4/2021. Since in the meantime, almost 3 years have passed, the appeal is disposed of with observation that in case the case is still sub judice before the trial court, the appellant is at liberty to renew the prayer for bail in the said court. Accordingly, appeal is disposed of. Yes.
Item 12.
May I please, Lord? I have supplied the deposition
now they
copy. Yes.
Learned counsel for the appellant supplied the deposition copy of the witnesses examined in the trial court to the learned counsel for the state in court today.
Except PW 9 ଟା ଦେଇନି seizure witness ର
My lord,
ସେଟା ନାହିଁ ମୋ ପାଖରେ।
here my lord, yesterday my lord, there were 2 cases in sub item and this is item my lord.
Hmm.
And it was a split up case both are.
Okay.
In the
It is to be tagged with that case or what?
no, that is has come my lord.
No.
The witness examined, the eyewitness examined in
Hmm.
both the cases. My lord directed to produce the eyewitnesses.
Mhm.
But what happened, my lord, here, my lord, Tamala Naik was
Hmm.
supported in first case, my lord, CRLA 563.
Hmm.
He has not been examined in that split up case.
Mhm.
And other witnesses, they have just verified, given me Basanti Naik and Rajeshwar Naik.
Hmm.
Whether they have examined.
Yes, yes.
Then
Basan,
one.
Rajeshwari is
Tell
the
me,
the
it
thumb-
has come today,
Huh.
all these matters.
All these matters.
So till one date we will keep it.
Huh.
if it-
Because my submission is that
Hmm.
let the direction be given to our state to produce the witness Tamala Naik in this split up case, my lord. Because he has supported here.
Hmm.
My lord asking about
he has not been examined there.
exactly.
Okay. No. If he has supported in
My-
and he has
My lord.
implicated also
My
the.
If my lord consider on that basis also ready.
No, we can consider
My
his evidence also.
My
There is no problem. So which are those items?
My
It
lord,
is, item number 12.
my lord.
And-
that is the main case.
Okay.
Connected case is the split up case.
The CRLA number 789
Yes.
2022.
I have gone through. We can take up, my lord.
Huh?
I have gone through all the.
No, you said
He
that.
just they have given the
Yesterday, your
because
lordship
copy,
directed.
but the copy he has
No, is it the same? Because the
Same.
witness may be different because it
huh,
is.
because some they have already solved.
Huh.
I was waiting for the deposition copy of the that particular, my lord, Basanti Naik and Rajeshwari Naik in this case, my lord.
No. If you say we can take up just now, there is
Well,
no problem.
well-
But you said that it has supplied.
Huh,
Has
just
been
a moment.
So, is there any difference in the evidence of the witness examined in the main case and the split of case?
No, nothing.
There is nothing. So, we can take up. There is
Well-
no. Yes. So, Mr. Sahu, you place your case. It's CRLA number 563 of 2022.
Jitendra Pal.
It is it's a sole appellant.
Yes, sole appellant.
Okay.
Custody, my lord.
Just a minute. Jitendra Polai. Okay. What is the date of custody?
8/5/21.
And what are the offences under which charge sheet submitted?
Charge sheet submitted, my lord. 143, 364,
Hmm.
302 by 34 of the IPC,
Hmm.
read with 3(2)(b)
Hmm.
of SC/ST Act.
What is the name of the deceased?
Tutu Naik.
Date of occurrence?
Date of occurrence is 16/3
15.
16/3/21.
Night.
Acha, 15/16/3
3/21.
2021. So, who are the eyewitnesses who have been examined in the trial court?
Yes.
Eyewitnesses, my lord.
Yeah.
Reboti Naik,
Just a minute. Reboti Naik,
PW8, my lord. In this case, my lord.
in this particular case,
Yes,
is PW8.
Tamala Naik,
TAMALA, Tamala Naik.
PW5, my lord.
Yes.
Bhavani Naik,
Bhavani.
Naik, my lord.
Yes.
Bhavan Naik, PW7, my lord.
Okay. So these are the three eyewitnesses.
Basanti Naik,
Yes.
PW11.
PW11.
And
Rajeshwari Naik, PW10, my lord.
Hmm. So what is the total number of charge sheet witnesses?
Charge
Yes.
sheet, my lord.
$18 million.
18,
18.
my lord.
Yes,
And how many of them have been examined?
11.
Okay. What role they have attributed? You can place one
My
of
lord,
them
I'm placing the
against
evidence
so far
of
as
Tamala
this
Naik.
Tamala.
Tamala.
Tamala means PW5.
5.
Where is that evidence? PW5 Tamala 9. Yes. What he has stated?
I know the informant of this case. Also, the deceased of this case, I know the accused Jitendra Palai, but I don't know the other accused person of this case, my lord.
Jitendra Pallai means the appellant. Okay.
My lord.
Yes.
2.5 years back from this date, in the Odia month, Phaguna, on 15th day, the occurrence took place at Nityanandapur colony.
Hmm.
There was some theft of Jitendra Palai and one Gouda Pradhan. Gouda Pradhan is my lord, another case with a sub item.
Hmm.
Gouda Pradhan, and for which in the said night, Jitendra Palai, Gouda Pradhan, and some other persons, total 10 in numbers, had gone to the house of Tuttu, deceased, and knocked the door of his house. Thereafter, Jitendra Palai, Gouda Pradhan, and other culprit assaulted Tuttu, and then they left the said spot. On the next day, at about 10 a.m., Jitendra Palai and other asked the informant and collected the phone number of Tutu from his wife. Thereafter, Jitendra Palai and Godabadhan, along with two other persons, assaulted Tutu and threw his body in the body of the informant. Thereafter, the informant shifted her husband to medical, but the doctor declared to be declared. I was examined by the IO.
Hmm. No, what is the weapon of assault?
Weapon of assault, no, not mentioned.
At least in the paragraph 2, she has not stated.
My lord.
And what the PM doctor noticed?
PM, my lord.
The doctor has been examined, not examined.
Injuries, my lord.
7 in each.
7 injuries.
What type of injuries are there?
My lord,
And please pass on the
left forehead.
anybody has stated about the weapon of offense?
No, my lord.
No.
The first one is on the right thigh, second one is left thigh. Contusion, then right
Right
calf,
calf,
right calf,
left calf.
multiple contusions, one so along with parallel bruises of different size, shapes and sizes.
Half of the forehead.
So it appears some kind of stick, etc., has been used. So that is how. Again on the left forehead, multiple so and so. Fracture of C to C3 with contusion of paravertebral muscles. All the above injuries are antemortem in nature, could be possible by hard and blunt trauma impact. Death was due to. That is the evidence of other eyewitnesses also.
Similar.
Any specific overt act has been
No.
attributed. And what about the criminal antecedent?
This Jitendra has no antecedent.
Okay. Your earlier bail application has been rejected.
No, no.
This is
It's
the
the
first
first
one.
application.
In the other case, what is the period of detention?
Yes, I'm in custody since 23/4/2023.
That is CRLA number 789/2023. Your case is a split of case.
Split up.
Okay. Gouda Pradhan. Custody date is
23/4/2023.
No antecedent.
23/4.
2023, my lords.
Okay. So in your case, how many witnesses have been examined?
So far, total 9 witnesses.
The informant, the
Yes.
wife of the my lord deceased,
Yes.
Rajeshwari Naik,
Hmm.
as PW 11,
10.
10,
PW 10.
10, in the
Hostile.
hostile.
Hmm.
He was also an eyewitness to the.
Others have supported. जो आपण कहिले
ନାଇଁ ସମସ୍ତେ ସପୋର୍ଟ କରୁନାହାନ୍ତି।
ତମାଳ
ତମାଳ ଗଲା, ରେବତୀ ଗଲା।
ଆଉ ଗୋଟେ ରହିଲା ଭବାନୀ ଆଉ ବାସନ୍ତୀ
ଆଜ୍ଞା,
ସେମାନେ they also supported.
in the similar type of.
Okay. अच्छा notice sufficient.
No.
All right, CRLA number 563 of 2022. Jitendra Polai. Mr. Sahoo and counsel appearing for the appellant submitted that the appellant is in judicial custody since 8/5/2021 and he has been charge sheeted under section 143, 364, 302/34 of the Indian Penal Code, section 32B of the SC/ST POA Act. The occurrence in question took place during the intervening night of 15/16/2021, and the deceased is one Tutu Nayak. He further submits that out of 18 charge sheet witnesses, 11 witnesses have already been examined, and none of the eyewitnesses examined in the trial court has attributed any specific overt act against the appellant. There is no criminal antecedent against the appellant, and at this stage there is no chance of tampering with the evidence, and therefore the bail application may be favorably considered. Learned counsel for the appellant had supplied the deposition copies of the 11 witnesses examined so far in the trial court to the learned counsel for the state, who after going through the same submitted that Rajeshwari Naik, bracket PW10, who is the widow of the deceased, has not supported the prosecution case, whereas the other 4 eyewitnesses, namely Tomala Naik PW5, Reboti Naik, Bhavani Naik PW7, Reboti Naik PW8, and Basanti Naik PW11, have supported the prosecution case and implicated the petitioner in the assault of the deceased Tutu Naik. Land counsel for the state also placed the post-mortem report, which indicates that the deceased has sustained some contusions on different parts of the body, including the forehead, and the injuries have been opined to be antemortem in nature and could be possible by hard and blunt object, and cause of death was on account of spinal shock due to injury to cervical vertebra. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, the period of detention of the petitioner in judicial custody, and absence of any criminal antecedent, I am inclined to release the appellant on bail, subject to condition that he shall appear before the learned trial court on each date when the case would be posted for trial. He shall not indulge in any criminal activities and shall not try to tamper with the evidence, violation of any terms and condition shall entail cancellation of bail. In the second case, that is CRLA number 789 of 2023, the date of custody is 23/4/2023, and 9 witnesses have been examined. And whether these witnesses have been examined?
My lords,
So,
majority of them, my lords.
no, Rebati Naik has been examined.
Only the Tamala.
Rebati Naik as PW6, she has been examined.
Rebati Naik is PW6.
My lords.
Tamala not examined. Then Bhavani Naik?
P5.
PW5.
Bhavani Naik, PW5. Bashanti Naik?
P9.
Yes.
Then Rajeshwari?
P8.
So here, out of 18 witnesses, how many witnesses have been examined?
So far 9, my lords.
9 examined.
Most of the eyewitnesses.
Okay, so do it accordingly. Dita karo sleep alga alga kori de dechi. Yes, both are allowed.
Grateful, my lords.
8 and 9 janto.
Obliged, man.
Grateful.
Item 13,
May I please, my lord? This appears before.
You have received the case diary, Mr.
No,
Tripathi?
Lord, case diary is not, but notice was served.
To get the case diary, will take up next week.
Yes, I am served the deposition copy.
You filed for the court also.
My lord.
Have you filed?
No, my lord.
You file it?
File it.
All right. So this is an application for condonation of delay. But somebody has already entered appearance. So what is the question of again?
Notice has been
He has already entered appearance. You are to just to get the case diary only.
Yes.
All right. And go through the.
notice has gone to.
So I am condoning the delay because the learned counsel for the informant is not present.
Yes.
Lekhandu, IN number
I am for
10.
informant, my lord.
Huh?
I am for
Oh, you are for the informant.
my lord. They are for respondents are appear in this case. They are enter their appearance.
Nobody is appearing for the appellant.
No, I am for appellant. I am the informant and appellant.
अरे बाबा रेस्पोंडेंट रो इन्फॉर्मेंट रो काउंसिल होउचंदी लेखाई छी रमेश चंद्र महाराणा.
Respondent, yes. My lord.
Are you for the respondent or appellant?
Appellant.
सिया कोनादी?
Here appellant is the informant.
Huh?
Appellant is the informant in this case.
Then who has entered appearance for whom? The Ramesh Chandra Maharana जो देखिले V नामा कहाँ पाई से फाइल कर देंगे? Oh, appellant is the informant in the case.
Yes, my lord.
Okay, it's all right. Ramesh Chandra Maharana 2 and 3. किए से मान? Mr. Tripathi,
They are accused in lower court. They are acquitted and the
in this, it's a this criminal appeal is against
acquittal.
acquittal. Okay.
Yeah.
Right. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 36 days in filing this criminal appeal under section 372 CRPC, challenging the impugned judgment and order dated 18/7/2022 passed by the London Presiding Officer, Special Court under SC/ST POA Act, Cuttack, in city case number 110 of 2016. None appears for the respondent number 2 and 3. After hearing the London Counsel for the appellants, also the London Counsel for the state, and perusing the grounds taken in the interim application, I am inclined to condone the delay in filing this CRLA. Accordingly, delay is condoned. IA is disposed of. Put up this matter on week commencing from 11th March 2020 for admission. खाली लिखी दियंतु, the London Counsel for the appellant supplied the deposition copies of the witnesses to the London Counsel for the state, and also Ajit Debe na,
Today, course of
Acha.
file.
and he undertakes to file a set of deposition during course of the day for the court. Hala? Okay.
Item 14.
Yes, Mr. Paul.
Item 16.
16, Mr. Amulya Ratna Panda.
Case under section 302 and 34 IPC, my lord.
You have filed an application for interim bail.
My lord.
Are you pressing it?
My lord. Last occasion, your lordship had
On
directed
what ground you are seeking for interim
the
bail?
wife of the petitioner is ill, my lord.
What instruction you have received?
Take good. India portal. Double.
Yes. What are these diseases? Have you seen it?
No.
ये एउटा बाहर करो. Type करो. गोटे गोटे बाहर करो. Excellent. First one. Okay, the first one is
Disorder.
this menstrual cycles
Yes.
disorder. It appears frequently, maybe within 7 days. Things are there.
Due to thyroid, this is happened.
Okay. What is the second one? Typed it.
Thyroid glands.
Yes, thyroid problem.
Yes, please.
Okay. Who is this man? What are the criminal antecedents?
There is no criminal antecedent.
That has not come.
Offense is under section 302, 34 IPC and 27.
What is the stage now?
My lord, till yet the trial has not commenced, my lord. And the last occasion, your lordship has rejected the bail application of the petitioner on 7/2/2023. And your lordship has directed, given liberty to the petitioner to renew his prayer after examination of the material witness, my lord.
So what happened?
Till now, the trial has not commenced, my lord.
No, not commenced means charge framed.
My lord, charge has been.
So why the witnesses are not coming or what?
My lord, witnesses are not coming.
So there are eyewitnesses to the occurrence.
My lord.
So Mr. Tripathi,
Yes, my lord.
your IO or IIC should appear and take the summons and of the important witnesses.
Yes.
I'm granting him interim bail for some period, but do these things so that the bail application can be considered on merit after those material witnesses are examined. All right, take down. IA number 94 of 24. This is an application for interim bail on the ground of ailment of the wife of the petitioner. Medical documents in support of the ailment have been annexed to the interim application. The London Council for the State was asked to obtain instruction on the interim application. Today, the Learned Counsel for the state has produced the written report of IIC Sadar Police Station, Balaswar, dated 19 to 2024, from which it appears as follows. Quote paragraph 1, 2, and 3. You are for the informant. The Learned Counsel for the informants also oppose the prayer for interim bail. Considering the submission made by the Learned Counsel for the respective parties, the averments taken in the interim application, the medical documents annexed thereto, and the report furnished by the Learned Counsel for the state, I am inclined to release the appellant for a period of 1 month from the date of release. While on interim bail, the petitioner shall not try to keep any contact with any of the prosecution witnesses or try to tamper with the evidence. He shall not indulge in any criminal activities. The IIC Sadar Police Station, Baleswar, shall keep close watch over the activities of the petitioner while on interim bail. Violation of any terms and condition shall entail cancellation of bail. Next, main case 11. The Learned Counsel for the petitioner submitted that when the petitioner earlier approached this court for bail in CRLA number 884 of 2022, while rejecting the said application as per order dated 7/2/2023, petitioner was given liberty to renew the prayer for bail after examination of material witnesses in the trial court. He further submits that even though charge has already been framed,
I may be pardoned, but the rejection order shows that charge has not been framed and the investigation is still open.
କଣ କହୁଛନ୍ତି ଆପଣ ପଚାରିଲି ଆପଣ ଗୋଟେ କଥା କହିଲେ ପୁଣି ଗୋଟେ ଇଆଡୁ
Sorry.
ସିଆଡୁ। The submits that till date the further investigation is under progress as would appear from the rejection order dated 7/11/2023. If that be the state of affairs, the Learned Counsel for the state shall instruct the investigating agency through the IIC of Sadar Police Station, Baleswar, to conclude the investigation at an earliest and submit the final form, whereafter the Learned Trial Court shall do well to expedite the framing of the charge and examine the material witnesses at the first instance. Summons on the material witnesses be served through the IIC of Sadar Police Station, Baleswar. The petitioner would be at liberty to renew the prayer for bail after examination of such witnesses. Both the applications are disposed of.
The interim bail
Interim bail granted for 1 month.
obligement.
Free copy of the order be handed over to the Learned Counsel for the state for compliance. Maitrajit Mahanti on Lekhive for the informant. Okay. So the CRLA, so also the IA, both are disposed of. Huh? Yes.
Item 17.
May I please your lordship, my lord. Last time my senior friend has given a list, my lord, those who are the vital witness, and my lord has granted time to for examination of them, my lord. They, in the meantime, they have been examined, my lord.
They have been examined.
Yes.
So give the copy
I
to
have
the
not,
state counsel.
not
You have gone through.
Yes.
So what evidence has come against these?
They turn hostile.
Turn
The only eyewitness turn hostile.
This both the cases are
three
interlinked.
cases, my lord. One affair.
No, it's all right. One FIR, this Jitu Maji, for you are appearing.
All cases, my lord. All cases I am appearing.
In all cases. So you are for the
I am
Mr.
for the-
Panda for the informant.
My PW1.
So nobody has supported the prosecution case. Okay, there are 3 cases.
Yes. One case, 3 petitioners.
3 petitioners, 1 case. So what is the date of custody of these persons? Different date or one date?
One date 13/7/22.
13/7/2022.
Yes, madam.
And what are the offenses under which charge sheet submitted?
341,
Yes.
294,
Hmm.
427,
Hmm.
506,
Hmm.
302,
Hmm.
34 of IPC,
Hmm.
along with 31 RSB and 2 VAF
31 RSV.
B.
Yes.
And
Then
2 VA
V and VA.
of a C statement.
Okay. What is the name of the deceased?
This is Kesari Machi, madam.
What are the total number of charge sheet witnesses?
32,
How many of them have been examined?
15.
15.
Yes, madam.
There is only one eyewitness, Mr. Tripathi.
Yes, was the wife of that
What is the name of that eyewitness?
Joymani.
Joymani Machi.
Joymani Majhi.
Yes.
She has been examined as PW?
One.
He also informant in this case.
Okay. Or the learning, तीनटा जगह common order कर दो. The learning counsel for the appellants in all these 3 criminal appeals submitted that the appellants are in judicial custody since 13/7/2022 and they have been charge sheeted under section 341, 294, 427, 506, 302 by 34 of the Indian Penal Code, section 31 R, S, V and 32 V, VA of the SC/ST POA Act. He further submits that in the trial court, out of 32 charge sheet witnesses, 15 witnesses have already been examined, including the informant Jayamani Majhi, the widow of the deceased Kesari Majhi, as PW1, and she has not supported the prosecution case. And nothing has come on record so far during trial against any of the appellants. This is the second application or the first one?
Third one, madam.
Okay. And in view of, though the earlier bail applications of the appellants have been rejected by this court, but in view of the change in the circumstances, the bail application may be favorably considered. Learned counsel for the state, after going through the evidence of the witnesses, fairly submits that the informant is the sole eyewitness to the occurrence and she has not supported the prosecution case. None other witness examined so far have stated anything against the appellants. Learned counsel for the informant, Mr. Panda, has also no objection to the grant of bail to the appellants. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, since the sole eyewitness to the occurrence being examined as PW1 has not supported the prosecution case, keeping in view the progress of the trial and period of detention of the appellants in judicial custody, I am inclined to release the appellants on bail allowed.
Obliged.
Item 18.
8 out of control.
May proceed.
Item 19.
May it be your lordship. My lord,
SC/ST bail matter.
my lord,
Yes,
there
well,
was
delay.
20
Delay
days.
is there.
What happened to the notice?
Notice are not.
Notice?
Jaini.
No information.
Jaini mulo.
Oh, it is first time আসছে?
That 2 times they took adjournment.
Okay.
20 days. 20 days delay. 20 days delay, my lord.
All right, notice has to go. Extra copy of the appeal memo along with the interim application be served on the land council for the state during course of the week. Baki usual order for the. So matter is to be listed on such and such date. So confirmation letter regarding service of notice, case diaries, criminal antecedent be obtained in the meantime. Yes.
Publish.
Item 20.
Yes, Mr. Roy.
May I please, Your Lordship?
Wakalatnama for informant not filed money kon agur order it lagi.
It was served, but nobody was appeared for which
Okay,
it was
okay.
served.
Now you have received the case diary.
Yes, ma'am.
Is it the first bail application, Mr. Roy?
My lord.
Single appellant.
Single appellant.
Kala Krishna Pradhan. What is the date of custody?
Custody 15/11/23.
Charge sheet submitted.
Charge sheet.
Yes, ma'am.
What are the offenses?
294,
Yes,
323,
yes,
506,
yes.
34,
Hmm.
31R,
Hmm.
31S,
Hmm.
32VA, 341, 307,
Just a minute.
307.
3032 V and VA.
VA, 341,
Hmm.
307, 32V.
ତାହେଲେ ଆପଣ 32B କହିଲେ କେତେଥର କହିବି? So it's a case of 307, not 302.
But in FIR, no 307 was there.
No, it's all right. So
Yes.
charge sheet submitted. So who is that NGO?
My lord, injured, my lord, is the informant.
What is the name of
His
the?
name is Godadhar Sethi.
Just a minute. What injury he has sustained?
Only they have given one kick blow, my lord.
He was squeezed that genital.
Okay. So he's all right.
Yes.
At the Learning Council.
And he has also one criminal antecedent 302.
And other accused person have been granted bail, my lords. Anticipated.
Under section 302.
What happened in that case, Mr.?
My lord, in that case, he was convicted on bail.
So
That was reflected. But this person is not the aggrieved party in that case, my lord.
all right, heard the Learning Council for the appellant, Mr. Royal, Mr. State Council. Learn Council for the state submit that notice on the informant has been made sufficient since 31/2024 non appears for the informant. Learn Council further submits that the appellant is in judicial custody since 15/11/2023. He has been charge sheeted under section 294, 323, 341, 307, 506, reduced section 34 of the Indian Penal Code, section 31 RS 32 EVA of the SC/ST PO Act. He further submits that the informant Gadadhar Sethi is the injured in this case, and in view of the nature of accusation against him, the bail application may be favorably considered. Learned counsel for the state submitted that though the injury report indicates no injury he has sustained,
Yes, Lord.
No injury.
that though the injury report of the informant indicates that he has sustained no external injury, but it is the prosecution case that kiye squeeze kar dala.
He says, my lord, କାତି ଧରି ଆସିଲେ କାମ ବନ୍ଦ କରି ପ୍ରଥମେ ମୋର ଯୌନାଙ୍ଗକୁ ଧରି ଛାତିକୁ ଲାତ ମାରିଲା, ମୁଁ ପଡିଗଲି, ପରେ
So
ବେକକୁ
just
ଛୁରୀ
give a kick to the
yes
okay.
give a kick.
He gave a kick to the private part of the informant.
No, my lord.
How?
ଜୀବନ ମାରିଦେବ ସେ ଜିଲୁ ମୋର ଯୌନାଙ୍ଗକୁ ଧଇଲା।
ଜିଲୁ granted
ଜିଲୁ।
That one, acha, one.
ଗାଳିଆ ମୋ ଛାତିକୁ ଲାତ ମାରିଲା।
That the all right. The appellant kicked on the chest of the injured informant. Learned counsel further submits that there is one criminal antecedent against the appellant for offense under section 302 of the Indian Penal Code, in which he has been found guilty and has been directed to be released on bail by this court
yes
in criminal appeal. Considering the submission made by the learned counsel for the respective parties, the nature of accusation against the appellant, the period of detention of the petitioner in appellant in judicial custody, I'm inclined to release the appellant on bail subject to condition that he shall appear before the London trial court on his date. Case would be posted for trial. He shall not indulge in any criminal activities and shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of this. Yes.
Replacement.
Item 21.
May I please?
Item number 25.
Extended, yes.
The medical declaration report
So
by annexure
you
1
have
by
obtained instruction,
My lord.
is correct.
No, my lord. No such order passed regarding the IA, my lord.
this is for the first time coming.
So I'm doing one thing, if it is, let him verify, and if it is found to be correct,
My
he
lord.
will be granted bail for 2
Right.
weeks, okay? IA number so and so. This is 209 of 24.
My lord, 24 my lord.
IA number 209 of 24. This is an application for interim bail on the ground that mother of the petitioner died on 21/2/2024. And in order to perform the obsequious ceremony, the presence of the petitioner is necessary. The petitioner is a man from state of Chhattisgarh. The Land Council for the state has not obtained instruction about the averments taken in the interim application. In view of the urgency in the matter, I disposed of the interim application with the observation that in case that the Land Trial Court, that is Session Judge cum Special Judge Malkangiri, after making necessary verification regarding the death of the mother of the appellant through the Superintendent of Police Malkangiri from the Superintendent of Police of Kankar district in the state of Chhattisgarh. And if the averments is found to be correct, shall allow the petitioner to be released on bail for a period of 2 weeks on furnishing to local sureties. The bail application is to be considered on merits after the petitioner surrenders after availing the interim bail period, and the Land Council for the petitioner produces the surrender certificate. Put of this matter in the week commencing from 27th March कर दिया था ना, week commencing from 27th March 2020.
Copy in course of the day my lord.
Yes, yes, that will be.
Deployed.
Item number 27.
Yes, surrender certificate not filed. Rakesh Kumar Das. All right, non appears for the appellant The appellant was granted interim bail for a period of 3 months as per order dated 16/10/23 in IA number 754 of 23. Land counsel for the appellant was asked to produce the surrender certificate. Since surrender certificate has not been produced, let instruction be obtained from the London Trial Court, that is Additional Session Judge Burgard, in city case number 318/46 of 2013-14, as to whether the appellant had availed the interim bail order as per the order dated 16/10/2023, aforesaid order dated 16/10/2023 or not, and if availed, whether he has surrendered at right time or not, and if not, what steps have been taken for his arrest, so also against the bailers. The report to be furnished by such and such date, file be placed before the London Registered Judicial to communicate the order to the London Trial Court. Yes.
Item number 28.
May I please, Lordship? I have filed a IA for granting leave to continue the criminal appeal,
Yes,
my lord.
Mr. Sanjay Kumar Das, who submits that he is to represent the state of Orissa Vigilance, and the name of Mrs. Josnarani Tripathi may not be reflected in the cause list. Henceforth, the name of Mr. Das be reflected in the cause list in place of Mrs. Josnarani Tripathi. IA number so and so. This is an application for condonation of delay in filing the leave application for continuing the appeal. After going through the averments taken in the interim application, and since the London Counsel for the Vigilance Department has no objection, I'm inclined to condone the delay in filing the leave application. Accordingly, delay is condoned. IA is disposed of. IA number 2863 of 2023. This interim application has been filed by the wife of the appellant, namely Revati Pal, with a prayer for grant of leave to continue the appeal in view of the provision under subsection 2 of section 394 of CRPC. After going through the averments taken in the interim application and hearing the London Counsel for both the parties, I am inclined to grant the petitioner Revati Pal to continue the appeal. It is submitted by this one so that the appellant died on 3/12/2019, and death certificate of the appellant has been annexed to the interim application, and the Aadhaar card of the petitioner has also been annexed to the interim application. So you are to file a phrase cause title in which
Yes,
the
ma'am.
name
Yes,
is to
ma'am.
be incorporated, and give a copy to the London Vigilance Council. So cause title, phrase cause title is to be furnished by the Land Council for the appellant within 2 weeks. Okay.
Yes, ma'am.
That's
Free copy of today's order.
free copy of the order be handed over.
Okay.
Item 29.
Mr. R.N. Barik, Mr. Bishwa Prakash Dhol. This is an An application for extension of interim bail means she was granted interim bail or what? This is appellant number 2 was granted interim bail. Krishna Chandra Varik. So no surrender certificate has been filed. $838 hour ka 'Appellant Sukro Parida. Sukro Parida କେବେ ବେଲ୍ ହେଇଥିଲା? ଏଇଟା ତ ଆର appellant number 2 ର that is Krishna Chandra Varik. Okay. IA number 838 of 2023. This is an application for extension of interim bail. The of appellant number 1, Sukho alias Sukhodev Parida alias Chutta. It appears that the appellant number 1 was granted interim bail for a period of 180 days as per order dated 12/8/2022 in IA number 483 of 2021. And he was asked to surrender to custody on 181st day of his release. In view of the passage of time, and since there is no information available with this court as to whether the appellant surrendered before the London trial court or not, I'm not inclined to entertain this application for extension. Accordingly, IA is disposed of. Let instruction be obtained from the London trial court, that is London additional session judge cum special judge Kulwani, in GR case number 41 of 2015, whether the appellant number 1 who was granted bail, interim bail in IA number 483 of 2021 by order dated 12/8/2022. So also the appellant number 2, Krishna Chandra Varik, was granted interim bail for a period of 3 months in IA number 196 of 2020 as per order dated 30/1/2023. Have surrendered in the trial court or not, and if not, what steps have been taken for their arrest, so also against their bailers. File be placed before the London Register Judicial and matter be listed in the week commencing from 18th March 2024. Yes.
Item 30.
Please, your lordship. On the last occasion, your lordship called for the report, the custody of the present appellant. Out of 12 years, now he is more than 10 years. Yes, what do you say?
My lord, custody certificate already obtained, my lord.
What is the years?
9 years, 6 months, my lord.
What is the date? Custody certificate date. 23/2/2023. In total, he has undergone for a period of
23rd February 2024. my lord.
copy
To take.
the.
My lord,
What is the offense here? Don't be bit too see. Say
12
local
years.
man or outsider? Man of local man, my lord, Sambalpur. Is a sole appellant.
Sole appellant.
Right. IA number so and so. କେତେଟା ଏତେ କ'ଣ ବେଲ୍ ଆପ୍ଲିକେସନ ଫାଇଲ କରିଛନ୍ତି?
ଇଣ୍ଟରିମ୍ ବେଲ୍ ଥିଲା କଣ
ନଟ୍ ପ୍ରେସ୍ କରନ୍ତୁ କୋଉଟା ଗୋଟେ। ତ ଏଇ 24ଟାକୁ IA ନମ୍ବର
147 of 20.
ଆଚ୍ଛା ମିସ୍ କେସ୍ ନମ୍ବର 1314 of 2016. This is an application for bail. Learned counsel for the appellant doesn't want to press this application, so disposed of. Hala. MC number so and so, stay realization of fine allowed. Hala. Baki IA number 147 of 2024. Considering the submission made by the learned counsel for the appellant that out of what is the sentence imposed?
12 years and 2 lakh of
Out of 12 years of substantive sentence imposed on the appellant, he has already undergone more than 10 years.
more than 10 years.
9 years, 6 months, my lord.
मतलब 3525 ହେଲେ
More than 9 years of sentence. And after going through the custody certificate dated 23/2/2024, issued by the Senior Superintendent, Circle Jail, Sambalpur. এটা ଦେଖୁଛି 3525 ଦିନ ତାକୁ ହରିଲେ 9 years, which indicates that the petitioner has remained in custody for 9 years 6 months. In view of the ratio let down in the case of such a Muslim case, Muhammad Muslim, I am inclined to release the appellant on bail allowed. Which is kept on record bail by the Yes.
Item 31.
My lord, I'm in custody since 4/12/2014, my lord.
You have filed your vhinama, na?
My lord.
All right. Peruse the prisoner's petition for engagement of Mr. Chandan Samantray, which is at flag K. Mr. Samantray has also filed his vhinama. The names of other counsel except Mr. Chandan Samantray and his associate shall not be reflected in the cause list henceforth. What is the conviction here?
11 years and 1 lakh fine, my lord.
And it's a NDPS Act,
My
madam.
lord.
How many years you are in custody?
My lord, 9 years.
Have you
2 months.
obtained that custody certificate?
No, my lord. Regarding custody
you got
certificate, no
one?
such order.
No, my lord.
Why didn't you obtain? So get that custody
My
certificate.
lord.
Which jail is the?
My lord, in 2014 he was arrested, my lord.
अरे कोई जेल ले अच्छी मत से आना
14 jail, my lord.
14 मगे दियो तो
My lord.
Learned counsel लिखो तो IA number miss के stay of realization of fine allowed. Now Mr. Samantray, there are bail. It is one appellant, na?
My lord, one.
You have filed 2 bail application. One is to be not pressed.
Not pressed. The interim one is, my lord, I will
Which
not
one
press.
is interim?
Interim one.
IA number 415 of 2022 is one bail application. Another is 241 of 23.
241 is the regular bail application.
Okay, so IA number 415 of 2022 not press. Baki 241 of 23 रे लिखी हुए. Mr. Samantray and counsel appearing for the appellant submits that out of 11 years of substantive sentence imposed by the learned trial court, the appellant has already undergone
9 years and
9
2
years,
months.
more than 9 years of sentence. Let the learned counsel for the state produce the custody certificate, put up this matter in the week commencing from 11th of March 2024. We stated to be lodged at Circle Jail Chaudhar Kardin. Hala? Yes.
Always.
Item 32.
May I please, Your Lordship? Last night, the Lordship Director for
as per the order dated 15/2/2024, put up this matter in the week commencing from 11th March 2024. The written instruction is often taken on record. এটা কোন লিখিছেন আপনি?
Share লিখছেন যে আমি ডক্টর
All right. Received from the IAC to that effect is taken on record. Yes.
Item 37.
What is this matter, Mr.
Your Lordship directed to instruction and inquiry about the two
Bill.
bailers because he's outsider.
Right, right.
I have given the instruction. It has been verified by the intelligence officers, and they are found that the address which has been given that is correct.
Correct.
But he was not present that point of time when the register were there.
No, it's all right. Present.
Yes.
He will be there in the before the trial
Yes.
court and
Only one issue is the verification of the Aadhaar card that is sent to the UDA state office. It has not been obtained. So I think
all right. So who are those two bailers? Because the names has to be reflected here.
Yes, name is one is Ishwar Chandra Sahu.
No, no, please show from the instruction received.
Yes, and last in respect of verification genuineness of the two last line.
Last line.
In respect of verification of genuineness of two
Bailor
bailers.
acha Smruti Ranjan, গোটা হচ্ছে স্মৃতি রঞ্জন সমর দাসী
Samadarshi.
সমর দাসী লেখা আছে
Samadarshi.
সমদাসী বাকি আরটা কি
আরটা হলো ঈশ্বর চন্দ্র
Sahu.
সাহু
ঈশ্বর চন্দ্র সাহু right. So you are convicted under section
22BC.
20B2C. Yes. What is the sentence imposed? 12 years.
12 years.
So how many years you are in custody?
5 years, 2 months. More than 2 months.
More than 5 years.
More than 5 years.
All right, take down. IA number so and so. This is an application for bail. The London Council for the appellant submits that out of 12 years of sentence imposed by the London Trial Court, the petitioner has already remained in judicial custody for more than 5 years. As he was taken into judicial custody on 25/11/2018 and faced the trial as UTP, which should be evident from the cause title of the impugned judgment. He further submits that since it is a criminal appeal of the year 2023 and there is no chance of early hearing, the bail application of the petitioner may be favorably considered. Stop. Mr. Tushar Kanti Satpathy, London Senior Standing Counsel, Central GST, Central Excise and Custom, as per the previous order of this court, has obtained instruction regarding the two local bailers and filed the instruction with a memo which indicates that the bailers are genuine and the documents are authentic documents. Considering the submission made by the London Council for the respective parties, the period of detention of the petitioner in judicial custody and in view of the available material on record, while not inclining to release the petitioner on bail on merit, particularly in view of the bar under section 37 of the NDPS Act, but in view of the period of detention, I am inclined to release the petitioner on interim bail for a period of 3 months. from the date of release, subject to condition. Yes,
My lord, if under section 32, more than
first we let us see your conduct. You first time you surrender and then file another. Then if you surrender at right time, then you can be released for a further period till the appeal is disposed of. Subject to condition that Ishwar Chandra Sahu and Smruti Ranjan Samadasi shall be the local bailers for the local sureties for the appellant. Put up this matter, fix a date after 3 months. The learned counsel for the appellant shall produce the surrender certificate. Yes.
item 38.
Rest of the matter after lunch we'll take.
I'll only item 40 I pray for next week, my lord.
40 millards. That is the interim, IA for interim bail
I pray for next.
on the ground of milord blood cancer of the appellant's daughter, milord.
My lord.
Last order 6/2 ରେ ହେଇଥିଲା instruction ପାଇଁ time ଆଉ ଆସିବ କାଲି urgency
already condoned. Already condoned and but last time directed to take reporting. The notice
Sir,
is on, sir.
12-2.
On the mail. Yes, yes.